Good afternoon. Here I turn up again. I would have assumed that people would have been a little tired of hearing me speak again and again. Uh, I must congratulate Dr. Agarwal for this lovely conference. We had, in my experience, the first real IP conference that really happened in India was 2005, when we actually held this Asian Patent Attorneys Association conference in India. And I was the co-chair of the organizing committee at that point of time. But unfortunately, that was only restricted to the members of APAA. And in 2006, 2007, and 2006, Ms. Agarwal started this, and it opened the doors for everybody to come and attend a large IP conference. Years ago, when I started my profession in 1981, as an IP professional, I started with one of the largest firms in the world called Remfry and Sagar. The only other firms in India were Deepening and LS Tower, and there were three firms who were actually doing most of the patents work. And the basic tenet of our profession was, do not share your knowledge. So we all kept our own professional knowledge as a trade secret. We wouldn't really discuss, we wouldn't come and attend any forum, we wouldn't share knowledge, we wouldn't speak about our views on anything, and we hardly played any role in the policy or governmental or legislative matters. A forum like this is an excellent change and a welcome change for this IP climate here, especially when we are in a very dynamic situation where there's so many new things are happening, and it gives a forum for everybody, the stakeholders, the attorneys, the policy makers, and also the people who are involved with the national rights and socio-economic conditions to come and express their views. And in spite of my 30 years of practice, every time I come and attend a forum like this, I just go back with so much tremendous knowledge and so much different ways of looking at things, and that's amazing. And I must really congratulate this forum for putting together an amazing array of speakers, a star-studded forum, and some young professionals. And earlier in my time, again, the young professionals did not have an opportunity to express their views. And today, young professionals come and speak their views as well. And while old is gold, I'm sure that sometimes, one likes change as well. And it's welcome change for young professionals to come and fearlessly express their view on various points. One of the things that we learned on this conference is that as opposed to and which I always knew, is as opposed to the common feeling that the Indian patent jurisdiction is very nascent. It's not. Actually, our patent jurisdiction more than 100 years old. But what is true is that we didn't grow much in this 100 years. And even when our patents law came into force in 1971, after we became independent, it was based on a bill which was started in 1950. So by the time our patents law came into force in 1970, it was based on a British law of 1949. It was already 25 years old. But the recent times there have been a lot of changes. But the changes during the GATT-TRIPS agreement time from 2005 to 2015, we made a lot of changes. And those changes were basically to comply with our duties under the TRIPS agreement. But did we really do that? Did we properly do that? Have we completely done that? There's a lot of questions, and there are two sides to it. Sometimes we would like to believe that we have, and sometimes we know that we haven't. So it becomes very important that we really know where the law is, particularly with the kind of a government that we have today, which seems to be pro-IP. It was the same government, actually, people have short memories sometimes, but I've seen three major changes in the Indian patents law. This is the very government which opposed the product patent regime in 1995 very, very heavily. And I'm aware that Congress, on the midnight of 1994, December 31, and I was sitting in the PMO's office, where we drafted an ordinance based on Article 70 and Article 70, Clause 8 and Clause 9 of the GATT agreement to actually bring in and make effective bail box applications. But fortunately, the government which opposed that all that years is now become pro-patent. But my worry always is that the pro-patent feeling is more a policy matter than actually a change in legislation. So what I would really hope and expect, and maybe succeed in doing it, because I'm one of the partners in this conference here and like to partner with this conference in future as well, that we are able to get in not only just some government officials, but actual real policy makers, legislators, ministers from law ministry, and judges who actually make a difference to be present here, so that we are able to express their views in front of them, and also structure the conference in such a way they are actually sitting alongside the stakeholders and they're able to hear. It's not that we give them put them on the first session and they speak and they run away. We actually have to have them here throughout the session, and they're able to really address, listen to the concerns of stakeholders, innovators, as well as people who represent on the other side, and take a very pragmatic and very clear, nice view, and so that in the future, the law becomes very clear. As a student of law, whenever we actually go to the court, we always like to have a quick decision. In India, we know that sometimes the judgments on trial take a long time. In my 35 years of practice, I have not seen one patent trial come to a full trial, really. Most of our cases are won or lost on the interim stage. And one of the most important points that we argue is on balance of convenience. But unfortunately, more often than not, what prevails is a balance of confusion, not balance of convenience. So it's very important that we have a clarity of law. And the clarity of law cannot be made dynamic. Clarity of law has to be a little static. And for that, we need to have some legislative interventions as well, not merely judicial intervention. So therefore, we need to have the right people and more important heavyweights from the government participating in this forum. So if not, we are able to make them completely agree with the views, at least we are able to understand their views as well. Because at this point of time, the Indian government is also trying to woo foreign investments into India. And if you want to have a lot of foreign investments in India, it's very important that the investors really understand the legal and the political climate in India before they put in their money. Particularly because when the money is put in here, it's very difficult for them to take the money out. And we do not have to. I remember way back ago in the Narasimha Rao government's time in 1995, Digital Equipment Corporation wanted to invest in India. For 7 years, we battled for them to invest in India. They got so fed up, and because of the government policy, and they went and invested in Singapore, and whole process took a matter of 3 months' time. And China is doing that now. So if we really want to woo investors in India, we need to give a very, very proper climate for them, and also give them a complete protection for their law and their rights as well. We often hear about public right versus the private right. When I was a law student, I always was taught that patent is a good thing and patent is important. It is better to have an expensive drug that will cure me of cancer than not have any drug which will cure me of cancer. So therefore, the Patents Act, and normally we know that under the law, any IPR for that matter, we know that under the law, it is possible to do anything that is not prohibited. So the law says that anything that is not prohibited is permitted. So normally it's common to copy. The intellectual property laws are exception to the rule of copying. So if you have to give monopoly rights, then we have to ensure that the monopoly rights are actually understand that monopoly rights are given under the statute. And once they are given under the statute, we got to ensure that there are statutes there and they're applied properly, followed properly, implemented properly, and given rights properly as well. So it's very important that we evolve there very, very quickly. And it is very easy for us to take a particular view and stay with it. The current view today is for India is to join the international forum and be amongst the developed world. So we cannot pretend to be a developed world and still be a developing world. Developing country. It doesn't work that way. So we need to take a stand. So if we want to be amongst the best in the world, I think we need to really work towards that and and I am a very pro-IP person. And that's what the profession is all about. And I would advocate for proper protection, understanding of the patents law, trademarks law, and all IPR. And of course, I know there are other side and other view as well. But the government must really make it very, very clear what is the stand it's going to take. Thank you. With this, I will.